Good afternoon. Welcome to Scott Law Team's latest Facebook Live event in our series, Can They Do That? Scott Law Team is also known as the employment law firm specializing in labor and employment issues. We represent both employees and employers, making us an excellent resource for your employment needs. We have the unique ability to anticipate arguments from both sides. I'm Pamela Nagel, a senior associate at the employment law firm. Today, I'll be talking about returning to work after being a remote worker. Many of us were forced to work remotely in 2020, myself included, and may still be working remotely due to COVID-19. As you know, companies had to figure out how to stay in business with their employees working from home. Maybe you're still working remotely because of COVID, or maybe you're working remotely for some other reason. Perhaps your employer allows you to work from home to make it easier to take care of young children, or maybe you're working from home because you have a disability and your employer is accommodating you by allowing you to work remotely. Some of us have a hybrid situation where sometimes we work in the office and other days we work from home. But regardless of why you may be working remotely, a question we often get at the firm is, can my employer force me to return to work? As are most answers to legal questions, it depends. Like nearly every other state, Florida is an at-will employment state, which means you can quit your job for any reason at any time, and your employer can fire you for any reason at any time, unless, of course, the termination is unlawful, which is a discussion for another day, another Facebook Live event in our series. But basically, unless you've signed an employment agreement that outlines specific dates and terms of your employment, you are an at-will employee. Your employer can therefore fire you if you refuse to return to work. Where you perform your duties is really up to your employer. It can be compared to your physical location at the office or other, physical location like a warehouse. But for argument's sake today, let's use the hypothetical of working in an office. I used to work for a law firm in Orlando, downtown, that was located in a multi-story bank building. The firm had 2 of those floors, and we were often taking the elevator back and forth between the floors to meet with different personnel and clients. And the firm had every right to decide which attorneys were located on which floors and which attorneys got the corner offices. And the firm had every right to decide what staff worked for which attorney, and they moved personnel around for efficiency and to accommodate the rotation of staff and attorneys coming in and out of employment with the law firm. Secretaries would need to be flexible to physically move their location from one attorney to another, and lawyers also would need to be flexible to move in or out of the corner office or to another floor, to our other floor in the bank building. So similarly, your employer can require you to move your physical location from your home back to the office. If that happens, you do have some options. Your options depend on why you're working remotely. First, if you need to stay home because of a disability, then you have the option of requesting an ADA accommodation. Second, if there are 2 or more of you that are working remotely and want to remain working remotely, you can make a complaint in concert to your employer, collectively complaining about the terms and conditions of the mandatory return to work. This concerted activity, where a complaint is made by or on behalf of 2 or more employees, is protected under the NLRA. We'll talk more about that here in a minute. And third, you can also politely request your employer to reconsider its decision and have a calm and professional discussion about your desires to remain working remotely. So let's talk about each of these options a little bit more in depth. If you're working remotely and your employer has asked you to come back to work, physically, and you want to remain employed, your first option, or one option, is to request an ADA accommodation. This option obviously is for those employees who do have a disability. Well, what is a disability? How do I know if I have a disability? A disability is defined as a physical or mental impairment that substantially limits one or more major life activities. A qualified individual must be able to do the essential functions of the job with or without an accommodation. So, for example, a grocery store cashier must be able to do math, scan the products, communicate with the customers, weigh produce. But what if this cashier cannot stand for long periods of time? Is that considered an essential function of the position of cashier? In my opinion, I would say no. And the cashier could ask for an accommodation of sitting if he or she was not able to stand, for a long time. But what if the employee had a mental impairment? This cashier employee, would that mental impairment, no, what if the employee had I didn't finish. What if the employee had a mental impairment that kept him or her from performing basic math? So is basic math an essential function for a cashier? I would say, in my opinion, yes. The employee would therefore not be able to perform the essential functions of a cashier. And that person may be better bagging the groceries. Another example is one of a warehouse and a stocker. And the essential function of the stocker is heavy lifting. So if an employee is not able to do heavy lifting, then that person could not perform the essential functions of the job and would not be able to require an accommodation because he or she would not be a qualified individual. It's unlawful for an employer to discriminate against an employee because of a disability. If your employer has 15 or more employees and you have a disability, you're protected from discrimination. If your disability requires you to work remotely, I would advise you to get a note from your doctor and present that to your employer asking for the accommodation to work from home. This accommodation would need to be deemed reasonable, and your employer does have the option or the right to offer a different accommodation that is also reasonable. If the accommodation of letting you work remotely causes your employer an undue hardship, then your employer is not required to give you the accommodation. Knowing these caveats that I've just explained should help you phrase your request for the reasonable accommodation of continuing to work remotely. And moving on to our next option, making a concerted complaint with 2 or more employees regarding the mandatory return to work. Your complaint would need to be about the terms and conditions of your employment to qualify as a complaint under the NLRA. So is there some issue with the physical location of your office? What exactly is the reason that you and your coworkers do not want to return to the office? If it has to do with the terms and conditions of your employment, make a complaint on behalf of 2 or more employees, and then that complaint is considered a protected activity. Why is that important? Because if later the employer retaliates against you, you would then have a valid complaint of retaliation with the NLRB. In order to instigate a claim of retaliation with the NLRB, you must file your complaint with the board within 6 months of the adverse action, or in other words, within 6 months of the retaliatory action of getting fired or being demoted or suspended after you made your complaint, your concerted complaint with 2 or more people. Now, the form can be found at the NLRB website. The link I've included here on the slide where you can get that form. If you need more information about the NLRB and the laws it protects, that is found at their website at nlrb.gov. Finally, if you're working remotely, your employer has asked you to no longer work remotely and you want to remain employed, you can always politely ask your employer to reconsider. Employers generally do want to reward their good workers, especially today in our culture of low unemployment and labor shortages. Employers really do want their valuable workers to be happy. So if you work hard, you have virtually no disciplinary actions and are making your employer money, then they most likely want to keep you and keep you happy. So my advice would be to, approach your employer appropriately and asking them to kindly reconsider and see what happens. I really do hope that you found this Facebook Live event helpful and informative. Thank you so much for listening to Scott Law Team's Can They Do That series. Goodbye for now from the employment law firm, and have a wonderful day.